Okay, the amendment process. I started talking about the Constitution by bringing up the fact that the Constitution has longevity. One reason the Constitution has longevity is because it is flexible. Often referred to as a living or flexible document, the Constitution is like a 200-year-old house, and it belongs to the living, not to the dead. And I don't own that quote, that's from Thomas Jefferson. But the idea is exactly comparable to home renovation. You know, I live in a house that was built in 1922. In 1922, you didn't really need closets. You only had one bathroom. You had a small kitchen. I wouldn't, in today's society with my lifestyle, there's no way I would live in a house with one bathroom, no closets, and a small kitchen. So I've had to make adjustments to that house. I've had to add on. I've had to update the electricity, update the plumbing, add another bathroom. Okay? It is a house that has now worked for me, but the foundation is the same, and the studs are the same, and the joists are the same, and the dirt in the basement is the same. So the foundation is still there. We've made it work for me and my style of living. Okay, so the Constitution is like that too. It's a 200-year-old house, but we've had to adapt it and accommodate it to a changing society. So one way, and the most formal way to do that, is through the amendment process. Now, formal amendments actually change the letter of the Constitution. They change how the judicial branch interprets the document. I've included a chart in here that kind of outlines the constitutional process. So for those of you who are visual, you can look at the chart. Those of you who like things written out, you can go ahead and look over here. Okay, so we're going to go through this process real quick. Proposing. Proposing an amendment just means suggesting. So you're suggesting a change. Now, there's two ways that can happen. An amendment can be proposed by 2/3 vote of both houses of Congress. So you need a supermajority in the House and a supermajority in the Senate. Or a rare or never used method of proposal is that 2/3 vote at a national convention. And this national convention, states send delegates. Okay, so you have state delegates that come from the state legislatures go to a national convention in D.C. and they vote on whether they would like to change the Constitution. Now, this has not happened since we've had a constitutional government. When did this happen? When did the state send a delegation to alter our government? With the Articles of Confederation. So 2/3 of the state legislatures going to D.C. to change the Constitution kind of makes people nervous. Last time we did that, we overthrew our government. Okay, the next step is ratifying, and ratifying means accepting an amendment. Now, this is done at the state level. Okay. Now, you have the most common way is that 3/4 of the states will, or three-quarters of the states will pass the amendment. Now that's hard to do because if you think of the composition of the United States, kind of looking at this map, your New England states are very different than your southern states, are very different than your Midwestern states, and your your West Coast states. So to get all of these 50 states on board, not to mention Alaska and Hawaii, with accepting a change to the Constitution can prove to be very difficult. Now, this process of proposing by 2/3 vote of both houses of Congress to passage by 3/4 of state legislature is the most common form of amendments. That's 26 times we amended the Constitution that way. The other time the other way is that you have 3/4 special convention at the state level, which means the state will hold a convention in its capital, like Richmond, and the people in the state will attend the convention, and the people will vote on whether or not to ratify that amendment. So that takes some of the responsibility out of the legislator's hands and puts it into the people, into the hands of the people of the state. Now that's happened for the 21st Amendment. So they allowed the people of the state to decide to end prohibition. Now, this whole amendment process is a great example of federalism at work. So if a faction were to take over at the national level, they couldn't amend the Constitution. They need the states to also agree to that change, and vice versa. So you can't have a faction take over one of the levels of government and tear apart the Constitution. How often does constitutional amendments happen? Not very often. We had the Bill of Rights 1 through 10 that were added almost immediately in order to get the Anti-Federalists to ratify the Constitution. So 1 through 10, an immediate add. Then you have the different types of amendments. A lot of our amendments are suffrage amendments, which deal with voting rights. Okay, starting with the 15th Amendment, then the 19th Amendment. Then you have the 24th Amendment, which does an end to a poll tax. You have the 23rd Amendment, which gives an electoral vote to D.C. The 26th Amendment, which gives your age group, 18 to 20, the right to vote. Okay, so a lot of them deal with suffrage rights. Ratification timeline, if you can't get an amendment passed in about 7 years, you can kind of forget it. Which brings us into this image right here. The ERA is the Equal Rights Amendment. Now, women tried, beginning in during the Progressive Era, in the 19-teens and 1920s, there was a push to get an Equal Rights Amendment added in addition to a women's suffrage amendment. And basically, equal rights would do what the 14th Amendment does for race, provide equal protection for people regardless of their race, ethnicity. And so the Equal Rights Amendment would give equal protection to rights based on gender. But it's never been passed, and we will talk about this when we talk about women's rights, but it's never been passed because people really just didn't feel it was necessary to differentiate rights between genders. But in the long run, it is easier to just kind of change your political tradition instead of changing the letter of the Constitution, easier to get through. There's been a lot of changes that we've made without actually altering the Constitution. Like before we limited the president's terms, Washington just set a tradition that the president would leave after 2 terms most of the time. Even though electors, according to the Constitution, aren't required to vote the same way the popular vote goes. Like if electors saw that the people voted in Miley Cyrus for president, the electors aren't technically constitutionally required to vote for Miley Cyrus either, but there is a tradition that the electors will honor the choice of the popular vote of that state. So there's a lot of things that we have in the Constitution there's a lot of things that we have in our politics and in our system that are just custom and tradition where we didn't feel it was necessary to change the letter of the law. Okay. You have the unwritten Constitution, though, because remember, this thing is flexible and there's ways to alter it without changing the actual letter of it. So you have to ask yourself, how has the government interpreted this document in order to give itself more power? And often the Constitution is informally amended. Why? Because it's quicker and it's easier. If you wait to formally amend the Constitution, you may never get that policy passed through and made into constitutional law. Now, the first branch and the first occasion where you have had the government interpret the Constitution in a way to expand their power was with the Supreme Court, which is scary because the Supreme Court is the only branch that isn't always accountable to the people. Once they get in, or now they're sitting on the bench, they can make decisions, constitutional interpretation decisions that have the force of law, that must be followed by the states and the other branches of government, but they're never reelected. So I'm going to talk about the case of Marbury versus Madison, which is really the first political soap opera, and I hope I can do it in 4 minutes. Okay. It all centers around the constitutionality of the Judiciary Act of 1789. Congress wrote, the framers wrote Article 3 to be very short. They don't really take the time to organize or structure the judicial branch. So once Congress starts working, they realize that there's a lot of holes left to how the judicial branch would work. So they started to pass a legislation that kind of clarified the organization and the structure of the court system. That law is the Judiciary Act of 1789. In the Judiciary Act of 1789, there is a clause called writ of mandamus. Writ of mandamus requires the court to force, so it's a court order by a judge, forcing a government official to carry out their duty. All right, so that's writ of mandamus is a part of the Judiciary Act that tells judges they have to force a government official to do their job, which leads us to the midnight appointments. Okay. The midnight appointments were judicial appointments made by John Adams before he left the office of the presidency. The Federalists had lost Congress, and the Federalists had lost the White House. So what branch is left? The judicial branch. So before Adams leaves his Oval Office, which it wasn't an Oval Office, but you get the picture, before Adams leaves office, he writes a bunch of judicial appointments for the federal court system to put a bunch of Federalists on the bench to be able to check the actions of the Democratic Republicans. Now, once Thomas Jefferson and his secretary James Madison go into the office of the presidency, Madison and Jefferson agree they're not going to deliver those Federalist judgeships. They were going to throw those in the trash, and they were going to appoint their own Democratic Republicans. Well, one of the guys who didn't get his appointment was William Marbury. And Marbury sued Madison under writ of mandamus, making the federal courts, or trying to make the federal courts, order Madison to hand Marbury his judgeship. In the end, John Marshall, who was serving on the bench of the Supreme Court at the time, decided he was going to avoid making a ruling. One, if he ruled in favor of Marbury, it would benefit his party, but it could also potentially get him impeached by the Democratic Republicans. Okay, or he could avoid making Madison serve up that judgeship, and then he would upset his own party. So what he decided to do is the Judiciary Act is beyond the scope of Congress. Hence, I love this. I wish I could, wish I could have done it with more zest and zeal. Hence, the act is unconstitutional, avoiding making a controversial ruling. Look at that guy go.